Good afternoon, everyone. My name is Michael Cunningham, and I'm the chairman of the Community Housing Resource Board of Anderson. I'd like to welcome you all to our Fair Housing Workshop. Just a few announcements. First of all, I'll start with thanking each of you who may be logged on or watching via live stream for giving us your time. Second of all, I would like to thank the City of Anderson and their staff for the long-term and consistent support for the Community Housing Resource Board of Anderson. And finally, I'd like to take an opportunity to recognize April as Fair Housing Month. And as the Community Housing Resource Board has traditionally done, we would like to always hold a fair housing workshop around the fair housing laws and or other information that we think is pertinent and relevant and important for our community to know. So after having said that, I'd also like to thank our board members for their support of the Community Housing Resource Board. And then I'd like to take this opportunity to introduce our presenter and guest speaker, Attorney Charlotte Osner with the South Carolina Legal Services. And Charlotte, I will turn the podium over to you, but not before also thanking you and South Carolina Legal Services for your also long-standing support of the Community Housing Resource Board and fair housing issues. So with that, Charlotte.
Thank you so much, Michael, and everybody else who's here today and who puts this event together for us every year. Well, I guess not last year. So like Michael said, my name is Charlotte Osmer. I'm an attorney with South Carolina Legal Services, and I'm here. April is Fair Housing Month, so we're here to talk about fair housing issues, and at the end, I'm also going to add a little bit about the CDC declaration because that's an ongoing issue that we're still seeing at our offices, and I want to make sure everybody knows about that. So briefly, I'm going to tell you about South Carolina Legal Services. Then we're going to talk about the Fair Housing Act. I'm going to give you some examples of housing discrimination, and then we're going to talk again about, like I said, that CDC tenant declaration. So Legal Services, we are a private, nonprofit, statewide law firm. We provide free legal assistance to low-income South Carolinians. You do need to apply for our services, but there is no application fee. And if your case is accepted, we do not charge attorney's fees. You can apply by telephone or online, but a lot of people think that we are a state agency. We are not. We are just a nonprofit, statewide law firm. So we have 9 offices across the state. We serve all 46 counties. The Greenville office serves Greenville, Anderson, Oconee, and Pickens County. This is what our office looks like in downtown Greenville. And so we handle a wide variety of civil cases, from consumer, education, employment, family, you need to get divorced, health, you're having issues, getting your Social Security benefits, housing, we see a lot of that, and elder law. What we don't do, we can't handle any criminal cases. We can't represent prisoners. We're also limited in class actions and lobbying and political activities. So to apply for our services, the main number you can call is that number listed on the screen, that 888-346-5592. You can also apply online at our website at sclegal.org. In certain cases, for when you have emergencies, if you've been served with papers, you could also come to your local office and apply for our services. We did have a new Anderson intake office twice a month. Obviously, because of COVID, that's been put on hold, but we hope to resume that once the restrictions have been lifted. So, fair housing. This law was signed in 1968. It's also known as Title VIII of the Civil Rights Act, and the purpose was to fight against what was then the widespread discrimination in housing. So the Fair Housing Act protects people from discrimination when they're renting, buying, or trying to secure financing for any sort of housing. So the prohibitions specifically cover discrimination because of race, color, national origin, religion, sex, disability, and familial status. So this is what's called the Federal 7. So as you can see, these are the 7 categories that protected characteristics that are protected from discrimination in housing. And so the Fair Housing Act covers most type of housings. There are some exceptions. And so mostly it's going to be smaller units where they, if it's like a landlord that just owns 1 or 2 units. So if it's owner occupied with buildings of no more than 4 units, that is not going to be covered by the Fair Housing Act. Also, we got single family housings that are sold or rented without the use of a broker. That's also not going to be covered under the Fair Housing Act. So what's prohibited? A landlord or a lender or a seller is prohibited from refusing to rent or sell housing. They are prohibited from refusing to negotiate for housing or making housing unavailable. You can't deny a dwelling. You can't provide different services. And you can't set different terms or conditions or privileges for the sale or rental of a dwelling. You also can't falsely deny that housing is available for inspection, sale, or rental. You can't deny anyone access or membership to these facilities. So there are prohibitions on what you can do when it comes to the sale and rental of housing. So in mortgage lending, you can't refuse to make a mortgage loan. You can't refuse to provide information regarding loans. You can't impose different terms or conditions on a loan, such as different interest rates, points, or fees. You can't discriminate in appraising property, refuse to purchase a loan, or set different terms or conditions for purchasing a loan. So in addition, it's also illegal for anyone to threaten, coerce, intimidate, or interfere with anyone exercising fair housing right or assisting others who are exercising that right. So that's called retaliation. So let's say if you went ahead and filed a complaint, you felt that you were being discriminated against when you went to rent a property. You file a complaint. It turns out that perhaps your underlying complaint was not actual discrimination, but you had filed that complaint and then you're retaliated for filing that complaint. That is still its own cause of action. So even if you didn't have a true underlying reason to file a discrimination complaint, it turns out it was unfounded. The fact that you filed that complaint makes you protected. So if that landlord went ahead and did something, you complained, you felt that you were being charged more in rent than other families, and then you filed a complaint, it turns out you were not being charged more in rent, but you had filed that complaint and that landlord tried to evict you, that would be considered retaliation and that would be protected. So it's also illegal to advertise or make any statement that indicates a limitation on preference based on the Federal 7. This prohibition against discriminatory advertising applies to single-family and owner-occupied housing that is otherwise exempt from the Fair Housing Act, as we had mentioned before. So this is where I'd like to mention the housing discrimination on Facebook. So a couple of years ago, ProPublica did an investigation where it determined that when on Facebook, if you're trying to rent a property, you could actually choose to exclude people who match one of the following criteria. So you can say African American, Asian Americans, Hispanic. And so you could restrict, based on the information that contained, who would receive your rental advertisements. So they were actually then slapped with their own discrimination charge. It was an ongoing issue with Facebook. They said that they were trying to work on it, but they were actually, the Housing and Urban Development HUD filed a complaint against Facebook for these very issues. So the Fair Housing Act also has disability protections. So the landlord may not refuse to let you make reasonable modifications to your dwelling or common use areas at your expense if they're necessary for you to be able to access or use the housing. Of course, it has to be reasonable. And also they can't refuse to make reasonable accommodations in rules, policies, or practices if necessary for the disabled person to use the housing. And we're going to talk about some examples of that in a little bit. And so, a building with a no pets policy obviously has to allow a visually impaired tenant to keep a guide dog. An apartment complex that offers tenants ample unassigned parking must honor requests from a mobility impaired tenant for a reserved space near her apartment if necessary to assure that she can have access to her apartment. So this is surprising, but people don't realize that one of the protected characteristics is also families. Sometimes landlord might think that a family with small children is going to be noisy and create problems, and so they just simply don't want to rent to them. That is prohibited under the Fair Housing Act. That was not one of the initial protections in 1968. That was later added in 1988. So what does this mean? What does this familial status actually protect? So if families in which one or more children under 18 live with a parent, a person who's the legal custodian, or some other designee with the parent or custodian's written agreement. Let me just check where I'm going with this. Okay, so I just wanted to mention this because this is what we see a lot. Let's say you are a grandparent and you've been taking care of your grandchild for several years. You're applying for housing, and the landlord or the housing authority says, nope, we cannot rent to you and add this child to the lease until you get legal custody of that child. That is not true, and that would be a violation of the Fair Housing Act. So all you actually need, and going to court, getting legal custody, is a time-consuming, costly case, and that's not necessary. So all you need is written permission from the actual biological parent, and this is one that I draft for our clients. This is a notarized affidavit, a notarized statement. It's not necessary for it to even be notarized, but as you can see, all you have to do is say who you are, who the child is, and you're giving permission to that person to take care of your child. That is all that's necessary. That's all that's needed in order to be able to add that child onto your lease. Or let's say you live in subsidized housing and you only have a one-bedroom apartment, and now you need a two-bedroom apartment because you're going to be taking care of your grandson. That's all that is needed to request a two-bedroom apartment. So are there any exceptions to these protections that family has? Well, yes, there are some exceptions because there are some subsidized housing complexes that are just limited to certain type of groups. And some of that could be, senior housing. So there are some units only rent to people who are over 55, over 65. So those are allowed to restrict families if their purpose is only to serve the elderly. So some examples of familial discrimination, they're not approving special requirements or conditions on tenants with children. You cannot locate families with children into a single portion of the apartment complex, keep them all together, and you can't charge higher rates for tenants with children. So what happens if you think that your fair housing rights have been violated? There's a couple of options. You can go ahead and file what's called an administrative complaint, and you can file a complaint with HUD, and you have 1 year to do that, and you can do that by telephone or by email, and you need to those are your options as far as, and the HUD is the U.S. Department of Housing and Urban Development. They are the federal agency that oversees the Fair Housing Act, but South Carolina also has its own state equivalent agency, which is the South Carolina Human Affairs Commission. Their deadline is 180 days from the date that the discrimination took place. So you would have 180 days to file a complaint with them, but it doesn't matter. If you missed the 180 days to file with the Human Affairs Commission, you can go ahead and still have that 1 year to file with HUD, the Housing and Urban Development. If you decide not to do the administrative complaint, it's not required. You can file a lawsuit in court. You have 2 years under federal law and 1 year under the state law. So do I need an attorney to file a complaint? No, it's not necessary to have an attorney to file a complaint with HUD or the Human Affairs Commission. If you're going to go straight to court, I would certainly recommend having an attorney if you choose to go straight to court, though. So these are some examples from the cases that I've handled at South Carolina Legal Services addressing some of these housing issues. So I had a single mother and her child had ADHD, and they were removing her and had initiated eviction proceedings against her because of the noise associated with that child's hyperactivity. And so she lived on a second floor apartment, and you had the apartment below who was complaining about all the noise that child was creating. And so that mother had repeatedly requested to have a bottom floor apartment, and the landlord had refused. So we were able to intervene and request that not only they withdraw the eviction, but they actually moved her to a first floor apartment, which then so that child wasn't creating floor noise from being on the second floor. We also had a situation with the Housing Authority, as I mentioned before, about that written permission, wasn't allowing grandma to add a grandchild as a household residence because the grandma did not have legal custody of that child. That is very straightforward. They're not required, they cannot require that a grandparent have legal custody of that child in order to be able to add them to the lease. We had another situation. We have older tenants whose sole income is Social Security disability income. That's the SSDI. And so when you're receiving SSDI, the Social Security disability income, you don't have a choice as to when you receive your monthly check. It's based on your birth date. So sometimes it can come as late as the 15th of the month, and most rents are due on the 1st of the month. So we've had situations where our tenants get continually charged late fees for paying rent late, even though they disclosed that they can't control their income and when they're going to get paid. So we are able to then request that they move the payment date so it coincides with the Social Security payment. We've also had situations with emotional support animals. We had a 7-pound Chihuahua that, when the landlord or the maintenance man would show up without notice, it was a little protective Chihuahua, but they were saying that Chihuahua needed to be muzzled at all times. That seemed extreme, considering that the landlord is required, unless it's an emergency, the landlord is required to give notice prior to entering the unit. So if they were just entering without notice, and let's say at that time my client had several doctor's appointments to assist every week, and they didn't give her notice, so her dog was loose in her apartment, and then the maintenance man would try to enter. They wanted her to have her dog muzzled at all times, but we reminded them that they were required to give her notice prior to entering her unit. And so now talking about South Carolina and a new case that we had just filed, we worked with the Lawyers Committee for Civil Rights in Washington, D.C., the Nelson Mullins Law Firm, and South Carolina Appleseed, based in Columbia, South Carolina. So they worked with South Carolina Legal Services, and we just filed this lawsuit last week in federal court. And so what was going on is that there was an apartment complex in Greenville that had been around since 1979, not many issues there, but it was purchased by a private company in the summer of 2019. And so in the summer of 2019, they had received significant amount of state funding through tax credits to renovate these units. And so as they began to renovate these units, they decided to run new background checks on existing tenants. As a result of that, they sent many notices to a lot of existing tenants that they had failed the background checks without additional information, and told them that they needed to vacate immediately or face eviction. So we said that this was illegal and discriminatory. And so this is based on this legal theory of what's called disparate impact. So this is a policy that a landlord or a lender might have that may seem reasonable or non-discriminatory on its face, but it actually has a discriminatory effect or an adverse impact against those those seven protected characteristics that we talked about. And so what would be an example, just to provide what disparate impact is? So if you have an apartment complex, only allows people with full-time jobs. Well, that might seem normal. As far as that seems reasonable, you want people who are going to be able to pay their rent on time. However, this would negatively impact people, disabled veterans, or other people who with disabilities who may not be able to maintain a full-time job, but they're going to get resources or income from other sources. So they might get VA benefits, they might get SSDI, and so that apartment complex should probably consider all income to assess someone's ability to afford rent, not just whether they have a full-time job. So that's what a disparate impact is. So in our case, we said that you deciding to run a background check on everybody, but whether you just had a charge, it only had information, and they made the decisions based on whether anybody just had simply a charge. They didn't look at the disposition in this situation. So it was just whether you had a charge. With a lot of criminal charges can be dismissed, they can be vacated, they can be reduced, and so making that decision simply based on just a criminal charge, we alleged is discriminatory, because people of color unfortunately come into more contact with law enforcement and have higher rates of arrest and charges than people of non-color. So this is something that we just filed last week. Okay, so now that we've been through the Fair Housing Act, I just wanted to clarify and give some additional information about the CDC and the eviction moratorium, since this was extended now till June 30th, 2021. This went into effect over this last summer when the pandemic hit. There was a federal moratorium on federally subsidized housing that you could not evict somebody for non-payment of rent. Now the CDC stepped in on September 4th and said that you could not, it only applies for people for non-payment of rent issues. So if you have a loss of household income and can't pay your rent, then you cannot be evicted as long as you comply with the requirements of the eviction moratorium. So this originally, like I said, went into effect September 4th, 2020. It was extended till December. It was originally supposed to expire December 31st, 2020. It was then extended till January 31st, then March 31st, and now June 30th, 2021. So if you have already completed this eviction moratorium and the declaration, you do not need to complete a new one. That is sufficient. But if you have not done so and you're facing eviction for non-payment of rent, it's very important that you get this document done. So this eviction moratorium does not cancel or forgive the rent that is already due. The tenant is still going to be responsible for paying rent and is not protected from eviction after June 30th, 2021. But for the time being, if you qualify for the declaration, it's very important that you get this document done to prevent eviction. So the form has changed a couple times, so this is the latest form, but like I said, if you executed the previous one, it is still valid. It just got updated this last time the moratorium was extended by the CDC. So you just have to state, whether first is to be whether you're eligible. And so determining what your household income is. And so if you have a lower household income, but really it's going to be the main qualification is if you have, if there's been any sort of loss of household income. And so it does not have to be COVID related. It just has to be loss of household income. And so I have a client who would sell insurance and wasn't able to sell as much insurance and so wasn't able to pay the rent. That counts. He said it was related to COVID. I had another client who lost household income because her daughter turned 18 and was no longer receiving child support. That counts. And so if that qualifies and if you still have to have an ongoing effort to receive federal funds to help cover your rent, but you need to, you can work with your landlord on that. But if you've had the loss of household income, then you're likely qualify for this. And then this is where you would sign on the second page. And we can make this available. I would think I'll talk to Miss Mary and have her, if we can have a link on the website so that you can have this document. And so if you meet these requirements, all you need to do is print out and sign this declaration. It is important to recognize that the tenant's going to be signing this document under penalty of perjury of law. So make sure that every requirement is met and that whatever you're signing, it is true. And so it's also important that every adult tenant in the household needs to sign their own declaration so that everyone in the household is protected. So it's just anybody over the age of 18 needs to sign it. And so after you've printed it, sign it, make copies of it. If you can't make a copy of it, take a picture. And then you're going to give the landlord that tenant declaration. You can do it in person, by email, fax, whatever. And then write down how and when you delivered that declaration to the landlord. And so the tenant is not protected until the tenant gives the landlord that declaration. And so if the landlord has already initiated eviction proceedings in court, then you need to do an additional document so that then the court knows about it. So under the CDC regulations, all you have to do is notify the landlord and present them with that declaration. But if eviction proceedings have already started, you have to let the court know what's going on. So this is just a form that we have that just lets them know that, yes, you qualified for the CDC moratorium, you've completed that declaration, and you've given that declaration to your landlord on so-and-so date. And that should stop the eviction proceedings until at least June 30th, 2021. So that's it for my presentation. I don't know if anybody would be able to have any questions or give me feedbacks, or if there is a procedure for doing that. But if anybody wants to reach out and send questions later by email, that also works. So thanks so much, everybody.